Okay, welcome everybody. I'm Saul Berkovich, CLA's Director of Governmental Affairs. A little bit of housekeeping before we get started. Our plan today is to spend about an hour going over each of the 12 propositions. We'll save a half an hour for Q&A at the end. If you have any questions, you can type them into the Q&A box at the bottom of your screen. I will see them and the speakers will see them, and then we'll try and get through hopefully all the questions in the half hour that we saved at the end. We have one slide per proposition with the official title and the official yes/no statement. So there's not a lot of reading material during the main presentation, but at the end of the presentation, we have an additional resource slide with links to lots of detailed material. We will be sending the entire PowerPoint presentation out to all of the participants, so you'll have a copy and you can click on the live links. And just to get this out of the way, the speakers today will not be advocating in favor of or against any particular arguments or positions, but they will be discussing what's being said out there in connection with each proposition and the interests that are driving the various discussions. We have two speakers. Professor Mary Beth Moylan is Associate Dean for Academic Affairs and Experiential Learning at McGeorge School of Law. Since 2003, she has supervised the publication of the California Initiative Review, an online journal providing objective and neutral analysis of each statewide ballot proposition. She and her students also hold a public forum on the statewide ballot propositions. They are doing a forum October 21 at 5:30 p.m. There is a link to register for that forum in our additional resource page. She launched her career as a law clerk for Judge Carlton in the Eastern District and then practiced election law and general civil litigation with two firms in San Francisco. Our second speaker is Ned Wigglesworth, the CEO of Spectrum Campaigns. Ned specializes in ballot measure campaigns and issue advocacy and has worked with stakeholders across the political spectrum on more than 40 initiative campaigns since entering public affairs 15 years ago. Before starting Spectrum Campaigns in 2016, he was a partner at Redwood Public Affairs, VP of Communications for California Medical Association, and a policy advocate at Common Cause. Like our other speaker, Ned was a litigation attorney at a law firm before entering public affairs. And as a former litigation attorney, Ned has worked with general counsels to provide strategic and communication support for litigation. And with that, take it away. First slide, please.
So I think I'll take it away with the legal landscape first, and then I'll turn it over to Ned to give a little bit of the political landscape. First, thank you, Saul, for having us and hosting this forum. I think it's such an important time to be talking about being educated in the initiatives and knowing what we're voting on. So any illumination that Ned and I can provide to that, I'm really grateful that we have this opportunity to talk to people, and thank you all for attending and being interested in hearing about the initiatives. As Saul said, I teach a class on the initiative process at McGeorge Law School. I've been doing it for a lot of years. The full reports that my students have completed are part of the resources that will be on that final slide, and you can link to them. So we're going to be giving a very 30,000-foot view of the initiatives because we don't have all that much time. But if you want a deep dive and you want a little bit more in terms of the legal analysis, I'd ask you to look at the student reports. They range in length from about 12 pages to about 25 pages each. And so they're a much more detailed look at each of the ballot propositions. In terms of a legal landscape, before we get started going through, I think it's just important to note that we've had this initiative process in California for over 100 years. It has been used more or less depending on the decade. This time around, we have 12 ballot propositions, and 11 of them are initiatives, and one of them is a referendum, and that's an important difference. And when we get to Prop 25, we'll talk about the role that the referendum plays. But basically, we as voters get to decide on these pieces of law. One other contextual point that I think is necessary to make this time around is that in recent years, we've seen an increasing use of amendment clauses. And that's because, generally speaking, once we as voters of California do something through the initiative process, it cannot be undone without going back through a vote of the people. That's an expensive proposition. That's a lot of effort. And so proponents have, I think, gotten a little more savvy in recent decades and started to include provisions that will allow for the legislature to make amendments without going back through the ballot process. So several of the initiatives that we're looking at this time around do have amendment clauses that will allow the legislature to make amendments without going back through the whole process. But one in particular has a somewhat outrageous amendments clause, which as a practical matter, I would argue, doesn't really mean that we will not go back through the people to make changes. So we'll talk about that when we get to that one. But I think it's important to understand that the default on initiatives is that they cannot be amended unless they go back through the full initiative process. Additionally, in terms of legal landscape, we'll be talking a little bit about what happens when initiatives get challenged, what happens when the ballot titles and summaries get challenged, and kind of the presumptions that are in place for the Attorney General's ballot title and summary. And so I think that's probably all I'm going to say about the legal landscape, and stuff will come up as we go along. And also, I'm sure that some of you may have questions. I'm going to pass it to Ned to give a little context on the political landscape.
Thanks, Mary Beth, and thanks, Saul, and thanks everybody for participating today. Just a few sort of introductory thoughts about the political landscape here. First one is we are going to see probably a record amount of spending on the California ballot measures for a particular year, for a particular election. I think we're on track to see probably somewhere between $650 and $700 million spent on ballot measures on both no side and yes side combined. There's 3 or 4 that are all going to see over $100 million combined, and a couple in which we're going to see one side spend over $100 million. So we continue to see spending increase in this arena. Part of the reason that we're seeing spending increase in this arena is the increase in voter registration in California, which is being driven by a few things. One, the broader sort of electoral environment and people being excited to come out and vote. Particularly in the presidential race here in California. Another reason is some of the recent changes in law that have been done in terms of motor voter that Alex Padilla, Secretary of State Alex Padilla, has spearheaded to have people automatically register effectively when they go to the DMV or when they get their license, et cetera. So all of those additional voters, and I think we're up to 21 million registered voters now in a presidential year. We're probably going to see something like 80% turnout overall. Means we're going to see a record turnout here in California. What we're predicting is probably going to be somewhere between 16.5 and maybe even $17 million, 17 million voters. And so when you think about what you need to do to go about running a campaign, particularly if you're in the business community, whether you're on the Dem or Labor side too, you have way more voters that you have to communicate to. And a lot of these voters are what we refer to as low propensity voters, which are they tend to be not very civically engaged. They tend to sort of, if they show up at all, they show up once every 4 years or once every 8 years, only for the presidential election. And so it's, there's both more of them, but they're also harder to communicate to because they don't really pay much attention to the traditional channels. So you'll see that's another theme that's going on. One other sort of theme that we're all dealing with, of course, is COVID. And I would suggest that there's a lot of uncertainty going on right now in terms of how many people are actually going to show up. But one of the other big changes that California made is that everybody's going to get a mail ballot this year. It's unclear whether that is going to in and of itself increase turnout, whether more people are going to use that easier access to the ballot to show up and actually vote. Early suggestions say that it's not going to. You'll also see that implicated somewhat in terms of how various campaigns are allocating their media resources across broadcast, cable, digital, mail. The COVID is having a little bit of an impact on that, but more really it's in that people are decreasingly watching broadcast TV and more turning to some of the targeted media, digital, streaming, et cetera. One last note, and then I'll throw it over to Mary Beth to kick off the actual propositions, is there is a tremendous amount of early voting going on in California this year. Some of you have probably seen it in what you've seen being reported out by the counties who start to process and report out their early vote by mail results. I think the most recent one from this morning said something like there are 14% of Californians, 14% of registered voters have already returned their ballot to counties, and the counties have reported that out. But in private tracking on a few of the campaigns that I'm working on, and I'll disclose that as we go through, but private tracking suggests that somewhere in the high 40% of the expected electorate has already voted. Something like 30 to 35% have already submitted their ballot by mail. There's another 5 or 10% that have filled out their ballot but not mailed it, and there's another 5% or so that have voted early at one of their early voting centers in their various jurisdictions. All of which is to say that there's this massive amount of people that have already effectively voted, even though many campaigns still have the bulk of their voter contact program left to go. And so that's going to be another interesting thing, another interesting dynamic to watch. And with that, we'll throw it back over to Mary Beth.
Yeah, and we can go next slide, please.
Great. So we're going to just jump right in and start talking about each of the propositions in turn. I'm going to give a little bit of a broad brush about what it does, and then Ned will jump in with political observations about each of them. Some have more or less to talk about, and so we'll allocate our time accordingly. For Proposition 14, this is the Stem Cell Research Bond Initiative. 16 years ago, the voters passed Proposition 71, which created the Stem Cell Research Institute, and the money is not all the way out yet from that. That was also a bond issuance for doing stem cell research, but the pot of money has dwindled down to a point where in order to continue doing this work, the Institute needs to have an infusion of funds. And so the California Institute for Regenerative Medicine, or CIRM, is looking for a new issuance of $5.5 billion in general obligation bonds to be issued to continue the work that it's doing. I guess importantly on this one, there is enough money left to wind down all the projects that are currently in development. So CIRM has, I think, carefully allocated to be able to do that. So if this measure does not pass, it's not that current studies will suddenly be over. They will do a phased out reduction, and also it may continue with private funding, or maybe the state will decide to allocate money there. That part is unclear. What they're seeking though is this $5.5 billion in bonds, and the arguments kind of for and against this go something like, we're doing incredible work, we're operating in the valley of death zone where there's not a lot of private investment funding for this type of study and this type of research into very specific kinds of diseases. The opposite side is this really hasn't panned out as well as people might have originally thought. There haven't been as many patents that have come out of this, which would have created some revenue for sustaining the Institute on its own. There's been a few patents that have resulted from investments in these that CIRM has made into studies in the past. There's some concerns about There's some concerns about whether CERM has been managed well and whether Californians are really benefiting. There's a lot of studies out there that show this has been great for California. It's a vital industry. We're attracting really great scientists. We're doing really great things. But originally, 16 years ago, when we created this institute through the initiative process, the federal government had said that it would not fund stem cell research of any kind. That landscape has changed now. The federal government does offer some funding for stem cell research, although, you know, if this administration continues, who knows? So that's a little bit of what this does. It's going to create a bond issuance. It's going to keep the California Institute for Regenerative Medicine going, and it's pretty straightforward. Ned?
Yeah, so on the politics side, you know, this boils down to basically the research industry and people who are concerned about cures for various diseases versus some taxpayer groups. We haven't seen a wide engagement from this across the sort of spectrum of California interest groups that you normally see with a lot of sort of broader measures. There's a couple of interesting cross currents going on in this. There's not a lot of spend on this measure. The spend is almost primarily on the yes side, which is Robert Klein, the initial proponent and funder of Prop 71 that Mary Beth mentioned, and a little bit of additional money, but there's not a lot there's almost zero on the no side. The two interesting cross currents here are, one, Californians' willingness to accept additional debt versus what's going on with COVID, so on the former, for the first time in something like 30 years earlier this year, and this was even before COVID really, California voters rejected the first school bond in something like 3 decades. And it's not because Californians generally don't think there needs to be more money for schools. They generally do. It's one of their top priorities, if not the top priority typically. It's just that concerns about affordability and about taxes and that sort of general milieu meant even though in the face of that, you know, something like $20 million spent on the yes side to almost none on the no side, that measure, Prop 13 on the primary ballot, lost. So there's this ongoing concern that we're going to see play out in some of these ballot measures where California's increasing concerns about affordability. It's very hard for people that not only just sort of stay even, particularly in the middle and working class here in California, but to feel like they're going to get ahead and to feel like their kids can get ahead. And this notion of cost and affordability and cost of living is a big part of that. So that's cutting against Prop 14. On the other side, obviously, COVID, people's concerns about it, people's concerns and desire to have some sort of cure for this disease, which is, you know, extends across the partisan spectrum, right? It's not a partisan issue at all. That's going to be arguing in favor of this measure. Ultimately, the yes side has the ability to communicate its message because it's got a little bit of money and the no side doesn't. So it's going to be interesting to see how this plays out.
All right, good. Next slide, please. Oh, this is a big one.
Yeah, okay, Prop 15. So I feel like Ned might have a lot to say about this one, but I will try to give you at least an initial rundown. I think there's been a lot of discussion of this one. This is an attempt at a reform of Proposition 13. We have a couple of ballot measures that attempt to make amendments to what was originally Proposition 13, which probably I don't need to explain to people on this call, but passed in 1978 and froze tax rates at the 1975-1976 levels and allowed for a 1% tax on the property valued at an acquired property value rather than a fair market value, and then allowed for up to 2% increase, no more than 2% increase on both residential and on commercial and industrial property. So that's what Prop 13 did. There have been attempts to amend Prop 13 in the past. Many of them, none have really gotten much traction. We made little tiny changes around the edges, but that overall structure of Prop 13 has been in place since the 1970s. So what this proposition does, what Proposition 15 would do, is to split the tax roll. So residential properties would remain valued in the way that they currently are under the Prop 13 formula, and commercial properties would change. And commercial properties that are valued at 3 million or more would be assessed at a fair market value and would be reassessed every 3 years, not just at the point of transfer. And that's important because it will mean considerably more taxes being paid by commercial property owners and industrial property owners, because the values that they're assessed at will be much higher than what their acquired values were decades ago when the properties were acquired. So Prop 15 also has a very express formula for what should be done with those additional revenues. And part of the nuts and bolts of the initiative are really about where that additional money will go. And the answer is it will go to schools, and it will go to counties. And so schools and local governments will be the beneficiaries of this increase in revenue. Now, there's a lot of back and forth about whether it really will increase revenue, whether it's really going to harm small businesses. There's considerable concern that even though there is a $3 million value cap, that a number of small businesses and minority-owned businesses are involved in leases that require them to pay what the property tax is that their landlord is owing on. And so the landlords won't qualify for the small business exemption, and the costs will be borne out by the small businesses who are leaseholders, not property owners. So that's a really quick way of describing what this does, I think. But I'll hand it over to Ned, and I might chime in later depending on what I hear him say.
So thanks, Mary Beth. Yeah, this is one of the big kahunas. This issue. So I'm working on this issue on the no side. This issue has been brewing for a long time. It is Labor has both threatened to put this on the ballot and also has filed measures to put it on the ballot in the past, but always ultimately withdrew it. For the labor community, this is that's like primarily CTA, SEIU, AFSCME, many others, but primarily those folks. This is their best possibility after an income tax that we've already seen twice in the last 6 years to get significant revenue in the door in a way which is politically viable at the ballot. And so Labor has been biding its time and looked at the big presidential turnout this year that we talked about earlier as a favorable environment for them to put this on the ballot. On the other side is the business community, and the business community, is not a monolith, but this is one of those issues where they tend to move in the same direction regardless of what sector they're in, because it has a broad impact on nearly every single sector. The polling on this is very close. This is going to be one of those ones which really comes down to the wire. I suspect the Labor has put in something like 40 million of its own money, but they've also been helped by Mark Zuckerberg, who's come in through the Chan Zuckerberg Initiative with another 10 million or so. The business community, I think, is ultimately going to have somewhere between 70 and 80 million dollars ultimately to defeat this on the other side. This is one of those key issues where you have two competing lenses, right? Sort of two competing narratives, both of which have some validity, right? And this is one of the reasons why folks who are in the middle and are going to be torn in both directions. One of these big lenses is the corporate California community, or generally the corporate community generally, has become incredibly successful and takes advantage of the law and tax laws in particular in such a way that the sort of little guy, Joe or Jill California, aren't unable to. And so that one lens on this is about simple tax fairness. This is about corporate California paying their fair share. on the other side, this other really big, just as valid, just as compelling lens is, yes, you may tax corporations with this. There's some argument about exactly who it's going to be on, but ultimately the people of California are going to pay higher prices because of this. And that circles back to that point from before that we were talking about in terms of the general issue environment, which is concerns about affordability, concerns about the cost of living. For a lot of folks, middle class, swing voters, working class folks, those are also a very compelling and effective argument. So ultimately, this boils down in some respects to, if you're a swing voter, and there's folks, even there's some like light Republicans, certainly a lot of NPPs, then there's some moderate Democrats as well who are in this sort of swing voter. It's going to come down to, is this really a fair tax, and do we need the money for key priorities? Versus, is this just a bridge too far in increasing the cost of living in California? And you're seeing that play out. You're seeing that play out in the context of all the mail that some of you may be getting, and certainly the TV, radio, and digital that you're getting as well. This is going to be one, I suspect, where both sides are going to be watching the returns in the days after Election Day, because we may not know. Come November 3rd.
Okay. So Bree, next slide. So this is another big one. We got a couple of big ones at the beginning, and I promise we'll make up time with some of the other ones, but this is another big one.
Yeah. So Saul, this is a big one, except that it's not a very complicated one.
Correct.
And so I think we can actually talk about it fairly quickly. This, all Prop 16 does is to repeal language that was placed into the California Constitution by Prop 209. It's a very simple strike of language that we put into our Constitution in the 1990s through Prop 209, and it simply removes the prohibition against affirmative action. So the consequence is it does not require affirmative action. It does not mandate that the state use affirmative action criteria, but it allows for state entities to consider affirmative action programs in public contracting, education, and employment. But again, it's not a mandate for it. It's simply removing the barrier that was put in place with Prop 209.
Yeah, and I don't know, Ned, do you have anything to add on that, or?
Yeah, well, I mean, I think the interesting thing about this is that there's folks who put this on the ballot. And this is one of the three measures that was put on the ballot by the legislature. Thought that this year was the right year, which is another theme of this general ballot on some of these measures, because of all the concerns about racial justice and all the concerns around criminal justice, the ongoing and escalating probably concerns about income inequality and opportunity in America and in California specifically, and about the divide between the haves and have-nots growing, at a faster rate, and that divide falling most heavily on people of color and women as well. So they thought this was the ideal year, and it may have been, and it still may be. I think on the other side, there's this fundamental challenge that the Yes campaign is going to have on this. The Yes campaign is probably going to get to $20 or $25 million. They had a bigger budget earlier, but I'm not sure they're going to be able to fundraise for it completely. There's very little money on the no side. Certainly no business community money, et cetera. But the challenge that the Yes side has, despite their financial advantage, despite this issue environment in which we're all sensitized and concerned and paying attention to these issues, is one simple question: is, do you believe that admission to education, and do you believe that contracting should be done should be merit-based? And that question even for California voters still polls something in the low to mid 60s. And so even as people want to, this issue has been sort of framed as a referendum on, do you believe something needs to be done to improve racial and gender equality? There's a lot of people who think in California that something needs to be done on both those fronts, maybe even a lot needs to be done on both those fronts, but they don't think that this particular way is the way to do it. And you're going to see that play out at the ballot box.
So I'm going to just give a little bit of pushback on the idea that this is about meritocracy versus, again, this is not a way. And I think that that's something that people are missing. This is not mandating a particular way of dealing with racial and gender inequalities. It's opening up the door to say there can be ways that we look at merit through a lens that recognizes past inequalities and how they may have impacted certain categories of people. So the other thing, though, that I would add, Ned, is that there, on the no side, there has been a fair amount of momentum in the Chinese American community that is very much coming out against this. And so there's been, I think, some grassroots activity there to support the no side of this particular proposition.
Yeah, and that's right, and I wouldn't disagree with any of that. I would say that when the PPIC pulled this issue 4 weeks ago, it was at 31 yes, 47 no. And so it's going to be interesting to see what it is that's, when we get under the hood and when we see what happens on election day, how that plays out.
Yeah, I think it's a hard one. I think people don't fully understand, and it is being billed a little bit as this will cause California to employ affirmative action, as opposed to this opens up the door for different possibilities of the way that that might look.
Okay, next.
Okay, Proposition 17. This is mercifully clear. I mean, in terms of just, it's not hard to figure out what this is doing. So under current law, there is an interesting division between parole and probation. So when a person goes to jail for a felony and they lose their eligibility to register to vote or to vote, and that does not become reinstated until they are released from jail fully or are on probation. You can vote when you're on probation. You cannot vote currently when you're on parole. What this initiative would do is, this is also a legislative constitutional amendment. So the legislature put this on the ballot this time around, and this would change the language of the California Constitution to specify and change election code sections to specify that a person who is released on parole can have their right to vote reinstituted and can vote. That the only time you are forfeiting your right to vote is when you are physically incarcerated. So just during the actual prison term, not during the parole.
Yeah, not a lot to add on this one. There's not a lot of money. There's not a lot of available polling. This is one of those issues which, at least based on the folks that have taken position on it, tends to break down on partisan terms, and if not parties, their general constituencies. On the one side, you have Democrats and the League of Women Voters and ACLU. On the other side, you have Republicans and some, not all, some crime victims groups. I'd be a little surprised if this doesn't pass this year, even though it's kind of below the profile, but we shall see.
Okay, next.
Okay, the next one is also fairly straightforward, legislative constitutional amendment. So the legislature actually put 4 measures on the ballot of the 12 this year, which is more than usual, I think. And so this one will allow 17-year-olds who will turn 18 in time for the general election to vote in the primary election. This is kind of a baby step towards allowing or reducing the voting age. It doesn't reduce it by much, but it would allow those people who will be eligible in time for the general election. I actually happen to have a person who is in this category. So one of my 3 children turned 18 on June 27th. He did not vote in the primary because when we had the primary election, he was not 18, but he is eligible to vote in the general election this year. So had this passed 2 years ago, he would have been able to vote in the primary as well as in the general election. It's, again, pretty straightforward. We already in California have 16-year-olds pre-registering to vote because they do so when they when they get their driver's license. So there's not a tremendous amount of additional burden on knowing who falls into this category and whether they should be eligible. But the basic idea is that we want to engage kids when they are coming to voting age, and that a way to do that is to allow them to vote in the primary, which usually is going to happen when they are in their spring semester of their final year of high school. So that's when they're getting civics. It's part of the mandated curriculum in California that they get civics education in that senior year. And so it's a little bit of strike while the iron is hot, while they're thinking about this type of government engagement, that we allow them to vote in that primary.
Yeah, this is another one of those issues which is breaks down on party lines. I think you know, all the arguments that Mary Beth said are right on in terms of what the sort of how the supporters are thinking about it. I think you'll hear from the Republicans that this is some sort of nefarious attempt by the Democratic Party to increase the people who can vote for them because they assume that young people are going to vote Democratic. That's probably a larger comment on how good a job the Republican Party is doing in communicating their positions to young people and persuading young people that they're a good party to back. But not much money on this one. And, you know, just for what it's worth from a practitioner's perspective, it's very difficult to get people 18 to 24 to vote in anything other than just like a once in a lifetime type presidential election, which we see some, and even then they still don't show up. And so it's not clear that despite the positive educational aspects that Mary Beth mentioned, that this is going to have much of a practical impact in terms of the negative consequences or concerns that the opponents have been raising.
Okay, next.
Okay.
This one's confusing, even to me.
Okay, Prop 19. I just want to, I know I'm being a little cheeky here, but it's confusing to you because we have a single subject rule that has no teeth. And that's maybe all I'll say about that. But I got a laugh out of Ned, so that's good. Okay, so Proposition 19 looks a lot like one that the voters rejected 2 years ago, which was Proposition 5. The legislature actually has put this one on the ballot as well. And what this would do is expand an exception to, well, it both expands an exception to Prop 13 and it contracts another exception to Prop 13 in terms of property tax rates and what can be transferred. So we talked about the residential piece of Prop 13, which freezes a particular tax rate at a particular point in time, and that is when the property is acquired, is when you get any reevaluation of value of a home value. So what we have in California are a lot of people who've been in their homes for a long time who have a low tax rate because their property tax rate was set at the time they acquired their home. Prop 19 would allow homeowners who are 55 or severely disabled or victims of natural disaster or wildfire, all those different categories of people would be able to transfer their tax rate when they sell one home and buy another home that they're going to live in. And it would not matter whether the new home was a higher value or a lower value, or where in the state the new home was. They would still be able to transfer with them their old property tax rate when they make that move. The other thing that it does, which is to my mind very tangentially related, is it creates a firefighters fund and also a fund that would help with fire protection and would help counties with absorbing some additional costs. So those fund creations are not so directly related to the transfer of the tax rate. However, the argument goes that because all of this is an attempt to assist vulnerable communities in California in terms of people who are older or disabled or have lost their homes due to natural disasters, that somehow it is connected enough, and that the money saved through these, the money gained through the sale of these homes and the ability to now tax other people for the homes that people are moving out of will somehow, we'll end up with more money, and that money will go to fire protection and to assist counties that might see a shortfall due to this proposition. Last thing, there is also within this measure a provision that says that if a home is transferred from parent to child or parent to or grandparent to grandchild, that the person who it's transferred to only gets to keep the tax rate if they are using it as their primary residence. So that is another change to existing law. Okay, that was a lot, and I'm not even sure it was clear, but it does do a lot of different things, and it's all, it all feels a little bit like a mishmash.
This measure was originally a ballot measure that the realtors, California realtors, were going to qualify for the ballot. And there was some last second end of legislation, sort of hanky-panky and drama around whether the realtors were going to move forward with their measure, and if the legislature was going to put its own version on the ballot instead. Basically, this boils down to this. The realtors are spending about $50 million on this measure. They spent, I think, 10 or 12 the last cycle when they did this, and it lost 58-42. They're putting this on the ballot essentially to free up what they perceive to be a chilling factor on the churn of California real estate. They believe that there's a bunch of people in their homes who don't want to move from one home to another because of the current tax law. And they think by passing this, and the realtors are a client of mine, and they think by passing this, that they are going to free up these people who are not going to be as concerned about the new tax liability that they would have if they're unable to carry it from one county to another. Because that's such a big impact and a big sort of shadow from people who have lived in their homes for like 30 or 35 years. If you lose all those tax savings, suddenly you're looking at a property tax bill that could be going up 3x, even for a similarly priced property. So that's who's on one side of this. On the other side of it, it's really confusing. There's not much money. It's generally some taxpayer advocates like Howard Jarvis. There's even a couple of legislators who are opposed to this because they didn't like the way it sort of happened. Another political thing that's interesting here is that, as Mary Beth explained, this is so complicated. Like I've spent a lot of time on this issue. This is really complicated. It's going to be interesting to see what happens and whether there's any hangover from the Prop 15 battle over commercial property taxes, and whether people are going to hear all that advertising and whether that's going to impact their vote on Prop 19. We've actually seen a push impact from one measure to another measure on prior ballots, and this is one of those measures which, even if it generally kind of makes sense, it's complicated, and if it gets some of that sort of that splash factor, that blowback from the 115 spending, it may be facing a tough night on election night. But right now, I think it's very close.
Okay, next, number 20.
Okay, number 20 is a voter initiative. It was put on by voters, and it is an attempt to both roll back some of the changes that were made by Props 47 and Props 57, which both were initiatives that aimed at criminal justice reform, sort of trying to ease the burden and make more people eligible for parole and make more clear when certain crimes should be charged as a misdemeanor rather than as a felony. We had, those are traditionally called wobblers. And so the idea being that Props 47 and 57 made clear that some of those wobblers should really be treated as misdemeanors. This initiative tries to move back some of those wobblers into the area of being treated more like felonies, in that this would allow for DNA collection for certain misdemeanors that used to be wobblers. It also adds to additional crimes, the crimes of organized retail theft and serial retail theft. So basically, I like to call them RICO shoplifting. But that's basically what it is. It's organized shoplifting, commercial shoplifting, and serial shoplifting. So those would be additional crimes if Prop 20 is passed. And there are also a number of provisions of the law that would add different parole considerations, making it harder for people who are convicted and serving their time to get out on parole. Yeah, I think that basically covers it.
So there's not a lot of spending on this one, but on the pro side is grocers, some law enforcement. On the con side, actually, is interesting. It's Governor Jerry Brown. One of the things that this does is it undoes some of the criminal justice reform measures, Prop 47 and 57, I think, that Governor Brown spearheaded in the last 6 or 8 years or so. And so he's come into this with some of his own political consultants and with some of the money that he had left over from the ballot measure committee. I have no insight on polling or how this is actually going to play out on election day.
All right, next, 21. Oh, interesting one.
Yeah, so Prop 21, again, we just saw an initiative relating to rent control, and that would have, the one we saw last time 2 years ago would have, which was voted down, would have eliminated the Costa-Hawkins Act that does not allow for local governments to impose rent control on any housing that was built after 1995. Sorry, I'm getting my decades wrong. This proposition would amend the Costa-Hawkins Rental Housing Act, but would not eliminate it. So what it would do is it would make 3 primary changes. The first one is that it would exempt the construction only in the last 15 years, so not going all the way back to 1995, but it would say that local governments cannot enforce rent control rules on housing that's built in the last 15 years. It would also keep the exemption for single-family homes only if only if the landlord or if the owner of the property owned no more than 2 properties. So somebody who owns multiple housing units could be subject to some local rent control. And then it would do away with the 1995 date altogether. So again, I think the important thing to recognize about this one is that it doesn't mandate rent control. It allows for cities and counties to pass rent control ordinances if the city or county believes that in their county a rent control ordinance would be helpful. So, but it does limit the types of ordinances that can be passed. It just opens up a little bit more housing to fall under local rent control ordinances.
And then on the political side here, this is another one of those $100 million ballot measures. The proponent is a guy named Michael Weinstein, who runs the AIDS Healthcare Foundation, who has put a number of ballot measures on the statewide ballot and also some locals down in Los Angeles in the last few cycles. He put the Prop 61 pharmaceutical prices one on the 2016 ballot. He put rent control on the ballot last time. He hasn't won any of these, whether at the state level or the local level. He is a thorn in the side, in this case, of the entire sort of landlord community, whether that's the small landlord or large landlord community. I think Michael Weinstein and the proponents of roughly 20 or 25 million. I think the landlords on the no side are now something over 75 million. So this is going to be one of those $100 million ballot measures. This is another one where there's a couple of key lenses going on here, right? Where these concerns that we've been talking about affordability and the cost of living in California and how that really stings people, right? People like, if you're a renter and you see this, you really like the sound of it, right? Because maybe I get some direct relief over the escalating rents, particularly in some jurisdictions. On the other side, other people, and particularly homeowners, hear this, and not just homeowners, some renters too. They hear this and they think either A, this is going to hurt my home value somehow, or B, somehow I'm going to end up being subsidizing these folks. And C, there's another argument in which somehow rent control actually increases housing costs, which is a little bit muddy to me, but that's the argument they're making. I think there's so much money on the no side here. I think this is one of those, I think it's ultimately they're going to be successful and you're going to see this go down again. But this is another one of those fascinating ones to watch through that affordability lens.
All right, next one. Okay, this is a big one, and this one in 24, I think are really good illustrations of the interplay between what the legislature is doing and the people are doing through the initiative process. This one probably more than the other one, but take it away.
Okay, Prop 22, my very good friends, because I get so many text messages about both sides of this one. I'm always getting messages from Alicia and Greg and all my friends on both sides. Okay, Prop 22. The history here is that the California Supreme Court issued a ruling in a case called Dynamax that made clear what the standards should be for determining who is an employee and who is an independent contractor under California law. The legislature codified that interpretation of the California Supreme Court in AB 5, and Uber and Lyft and DoorDash and all of the app-based transportation and delivery companies do not like that interpretation because it does squarely place their drivers in the category of employee and not independent contractor. So they, I think, sought exemptions through the legislative process and did not have luck. And there have been several determinations in the courts and in the legislature that the people who work for app-based transportation and delivery companies are, generally speaking, under the law, employees. This proposition would change that. This proposition would put into our statutes a kind of hybrid set of rules that would give some employee type benefits to app-based drivers, but would classify these workers as independent contractors and therefore would not provide other, I would say, both rights and responsibilities of employment or of employee status on people who work for app-based companies. There are some other pieces that this does, including putting in background checks, and there's some formulas for payment and mileage that would be expressed in our statutes. There are some. There's a criminal misdemeanor thrown in here that impersonating an app-based driver would become a crime. So there's a lot of kind of minor things, but the most major thing and the real point is that it creates a statutory codification that would say that app-based drivers are independent contractors, that they get some kinds of protections, but not the full protections of being employees under state wage and hour laws, under state workers' compensation laws, and under other state employment laws that relating to employee status. Last thing that's really important about this one, I alluded to it in my opening remarks, the amendment clause of this one requires a 7/8 vote of both houses of the legislature. So as a practical matter, I would say that the chance of getting a 7/8 vote to change this law would be unrealistic, and it would very likely need to go back through a vote of the people if there needed to be amendments. I'll stop there because I could go on, but I think Ned actually works on this one, and so maybe I'll chime in if he's being too one-sided.
That's fair. So I'm working on the yes side on this and have been for the last couple of years. So the money on this is, on the yes side, it's Uber, Lyft, DoorDash, Instacart, Postmates. I think collectively it's something like around $190 million when you look at all the in-kinds, but it's really about 180 to the committee itself. That is a national record on spending for one side of the ballot measure. So it's a tremendous amount of money. This is one of those, this is another measure where there are very strong competing lenses. On the one side there, it's tapping into that sort of sense of that the growing divide between the haves and have-nots, growing sense of insecurity that we've been talking about, growing sense of corporations making, getting benefit at the expense of sort of the little guy, right? Or sort of Joe or Jill, California. On the other side, there is the lens, which is the vast majority of drivers, many of whom are part-time, really like being an independent contractor and they don't want to be employees, and it kind of fits their lifestyle. And so on the Yes campaign, you're hearing about how this is protecting, this is Prop 22 by protecting this independent contractor model for these app-based companies is going to protect lots of jobs. And is going to, and Mary Beth alluded to this, they sort of throw in, we put in what some folks would sort of say are sort of sweeteners, right? But like things like a little bit of healthcare benefit when you reach a certain amount of hours driven, some workplace insurance, and a couple other things. This is also another one of the competing lenses here is this is labor, who is looking at a deteriorating percentage of the California workforce, right, in terms of those that are unionized or organized. And one of the reasons that you see that is because of the shift that we've seen in the economy from being a manufacturing base where most jobs which are heavily unionized, to a services economy, and particularly the tech services economy increasingly, where a lot of those jobs aren't unionized. So part of labor's lens on this is not just sort of one of basic fairness. It's also sort of part of a broader existential battle that they're fighting, which is how does labor engage in the new economy? How do they go about organizing in a new economy? And just really plain spoken, you can't organize independent contractors into a union. You can organize employees into a union. So, we mentioned the money here, the Yes campaign. The Attorney General gave a fairly a difficult ballot label to the Yes campaign, but the Yes campaign should win by a decent margin on this, just given the tremendous financial advantage they have. And I would just add one final thing is that we've also there's so many drivers that support it because they really do want to stay independent contractors, even if they wish they had a better deal as independent contractors. They don't want to work for companies. They don't want to be an employee. That having all the faces of drivers that I'm sure all of you are sick of at this point, right? And not just the text, but on your TVs, on your screens, on streaming, on radio, on mail, all that stuff is also probably going to help 22 get across the line by a fair piece.
So I feel like I need to just throw one more thing in, which is that the other concern that I think comes up on the no side is that this is a slippery slope. And so as this industry codifies like special rules for app-based drivers and in transportation and delivery companies, and we have all these special rules for this version of independent contractor, the fear is that we will see a similar proliferation of other industries attempting to skirt the employment laws and the workers' compensation laws and the other types of protections that are in place for their own employees. And we'll just see a whole bunch more of these ballot measures specific to each individual industry. So I think that's a concern.
Okay, 23, we got 2 more to go.
We got 3 more to go actually, but that's okay. 23, 24, 25.
Oh, yeah, sorry. 3 more to go.
23. So in the vein of yet another one coming up again that we just saw, we had a dialysis initiative on the last ballot as well. It didn't pass. It's back again, but in a very reworked fashion. So the current version of the dialysis chronic dialysis clinics, CDCs, this measure would require an on-site physician to be present at any CDC, chronic dialysis center, anytime they're open. So the argument goes, there's problems in chronic dialysis centers or clinics, not centers. They're not sufficiently careful. There's infections, there's problems. And so this is an effort to fix that. But the way that it's fixing it is by requiring a physician, not necessarily a person who is an expert in kidneys or in dialysis, but just a physician to be present at all times. It also creates some additional new reporting requirements to the California Department of Public Health. Currently, and I should say the third thing that it does is it mandates that there not be discrimination in services based on the type of insurance that someone comes with. So a dialysis clinic could not discriminate against someone because they have Medicare or Medi-Cal or Medicaid versus private insurance covering their dialysis care. The challenge on this one is that currently kidney dialysis or chronic dialysis clinics are regulated already by the California Department of Public Health and are regulated by the federal government, especially because they do take a lot of Medicare and Medicaid patients. So they already have substantial reporting requirements. This creates some new ones. There's a concern that for some smaller and nonprofit CDCs, this will be a cost prohibitive proposition. Like they can't afford to hire a physician to be on staff at all times. Anyone who's coming in to get dialysis is already under the care of a physician, and so the idea that you just have a particular physician sitting there is one that is problematic and may result in some closures. So I'll hand it over to Ned.
So this is a reprise from last cycle, just like a lot of these are. This is also, the proponent of this is SEIU UHW, which is a healthcare union who also put the last one on the ballot. In some respects, this is viewed as a UHW trying to organize the dialysis clinics and using these ballot measures as leverage to do so. The dialysis companies are going to outspend the UHW on this, something like $100 million to $10 million. They did, I think it was 115 to 10 or 15 last time, with like the similar massive financial advantage for DaVita, Fresenius, and U.S. Renal Care, which is essentially the dialysis industry. They've got some doctors on their side as well, the State Medical Association, the American Nurses Association of California. Ultimately, the question is going to be, and this is one of those, what will be a textbook case of the use of the ballot measure process as leverage to achieve a related but separate goal is, does UHW have the ability to put one of these on the ballot every cycle for $10 million? And is the dialysis industry essentially going to be okay spending $100 million every cycle to defeat this? And at what point, this is UHW's perspective, at what point do the shareholders of these dialysis companies say, enough is enough, we'll organize? And so, 23 is going to go down probably this year, and probably by 15 points, maybe 20. But that's not really the point.
Okay, 24.
Okay, 24 is about our consumer privacy laws. This seems to be, again, a fairly complex, multifaceted initiative that would make changes to what is already a very strong consumer privacy, consumer data privacy law in California. So we have, there was a previous initiative that actually got passed by the legislature that was brought by the person who is behind this one, who is Alistair McTavish. And he got his first effort through the legislative process. We have the CCPA, which is a fairly strong privacy protection for our data. There are opt-out provisions of companies being able to sell data. And this one would relate to data sharing as well as data selling. And it would, in some ways, make our data protection stronger. And in other ways, it actually loosens things up a bit. I think the most interesting thing about this one is that it does have an amendments clause that allows for amendment by a simple majority vote, but it has to be consistent with the purposes of the initiative, and there are 3 pages worth of purposes. So I feel like any attempts to modify what we would be passing here in Prop 24 would result in litigation over whether the amendments would be consistent with the 3 pages of articulated purposes for this particular measure. All of this is well and good, and it's great for California to have strong data privacy protections. Unfortunately, because we don't have this level of protection at the federal level, as soon as you walk away from California with your cell phone, all of your data is up for grabs anyway. So I think it's important to say that and for people to understand and know that we can only do so much as a state in terms of protecting and securing our data. Ned?
Yeah, so this is a really sort of interesting measure. The funding on this is all McTaggart. Something like $10 million to, I think, the California Nurses Association to put in $20K on the no side. I'm involved with the no side, so full disclosure on that. What's interesting about this is it's a couple things. One, it's a super complex issue. You see that borne out in part by the fact that you've got consumer privacy advocates on the no side. You have a few consumer and privacy advocates also on the yes side who are disagreeing about the nature of this. It's also interesting in that State Senator Bob Hertzberg, who some folks on the call may know, he played a big role in working on the language with Alistair McTaggart. And it's interesting for a legislator essentially and pretty uncommon, particularly for a Democrat, to not go through the legislature and not go through the legislative process, particularly on an issue which is so complex. The ballot measure is 52 pages long, and Mary Beth alluded to the difficulties of how you go about actually the legislature amending it. And there's all sorts of conflicting principles even within those pages, which make it really hard. And which, this thing is going to be, for those folks on the call who are litigators, there's going to be a lot of litigation on the changes on this thing.
Except, Ed, let me jump in and say, except for the litigators on this call, it does not create a private right of action or any, and that is a big sticking point for the privacy advocates who are either not taking a position like EFF, Electronic Frontier Foundation, and for privacy advocates who are against it, because the thought is that there really would need to be a private right of action if you really want enforcement of this thing. Although it does create a whole new agency that would do the enforcement of this new law. So that's $10 million. Sorry, go ahead, Ned.
No, those are good. Those are excellent points. Thanks, Mary Beth. Just final thought. We expect this to pass. It starts somewhere in the 60s, and without a funding, and the no side has no funding. The side I'm working for has $0, but $20,000 against something like 10 million, and so we expect it to pass fairly handily.
Okay, 25.
The sole referendum.
The sole referendum. So Proposition 25 is a referendum, which means that the people who do not like this law wish for you to vote no. How to say it's a little confusing. So the legislature passed SB 10 and eliminated the cash bail system in favor of a risk assessment tool and risk assessment system for determining who should be released, both pre-arraignment and pre-trial. The proponents of this measure wish for you to vote no. So the proponents, the people who brought the referendum, do not like the law that the legislature passed and therefore are pursuing a no vote. The opponents, the people who like the law, if you like the law, you're an opponent and you vote yes. If you don't like the law, you're a proponent and you vote no. It's a little backwards, but that's the referendum process. So in order to support SB 10 and say we like the elimination of cash bail, we like the idea of a risk assessment being the mechanism by which we determine people who are released, then you vote yes. If you don't think this is a good idea, if you support the cash bail system, or if you think this is the wrong way to go about eliminating the cash bail system, then you would vote no. I think, Ned, you're going to have a lot to say about the money on this one, so I'll let you do it.
Well, I think, the money on this one is actually even up, at least it was the last time I saw. There's a lot of folks who sort of are bail reform advocates and also labor. This has been a big priority for SEIU, which was a little odd when they were pushing for it, but they've also put their money where their mouth is. And then on the no side, it's actually both a mix of sort of the bail bond folks, but also sort of the insurers that provide the backing for those folks. And so it's sort of one of those sort of industries that you don't really think about, that you're seeing the money in this play out. And then I would just offer, referenda are always confusing. They're always confusing. But if you are a industry who doesn't like a law that was passed, it is easier to get a no vote on a measure than it is to get a yes vote. And so we saw, for example, the oil industry try to referend parts of AB 32, or sorry, not try to referend, it went to the ballot to do a separate initiative to try to overturn AB 32 14 years ago. And they kind of got their hat handed to them a little bit. If they'd gone the referendum route where they had a no campaign instead of a yes campaign, it very potentially could have been different. I have no idea how this is going to play out. This is another one of those only in California kinds of measures where there are prison reform and social justice groups and racial justice groups on the no side, because they, even if they don't like the bail system, they don't like, I believe, the latitude that this gives some judges in overseeing what the new system is going to be.
So they're actually concerned, what those groups are concerned about is that the risk assessment formula, it's all based on algorithm, and they're concerned that the algorithm is actually biased and will lead to more kind of racial bias in the determinations of who is released and who isn't. And that it's not so much that the courts have discretion, because this particular measure identified this particular tool and suggested that there needed to be this algorithm-based assessment being done. And that's of concern. And that's where that plays out. Before we go to questions, I was scrolling through the questions and I wanted to make one slight correction. Somebody asked about Prop 23 and the fact that it says in the official summary that it can be a physician, a nurse practitioner, or a physician's assistant. The reason that it says that is because there is an exemption, that there's a 12-month exemption that can be given if applied for to allow for a nurse practitioner or a physician assistant to take the place of a physician, but only if there's a showing that there's a shortage of physicians and it's only a 12-month reprieve from the physician requirement. So I just did want to clarify that one point. Okay.
Okay, cool. I think that's it for the main presentation. Real quick, next slide, Bree.
There's additional resources. As I said at the top, in case people hadn't joined yet, we're going to send the actual PowerPoint out to everybody who's registered. So you'll be able to click on the live links. Next slide. 15 seconds on this. So this particular presentation was open to everybody. This is part of the CLA's public education function. But I would encourage all of you to look at our website, California Lawyers Association, not the state bar. There's still some confusion about that out there. And to look at all the cool stuff we have. These links are also live when we send the presentation out to you. So with that, I think we're going to try and get through the Q&A. I can't guarantee we'll get through everything in 15 minutes, but I think we can save this and maybe get back to people if we don't have time, but I'm just going to go through an order. And my queue stopped at 21. I don't know if you have 23, maybe it's a technical thing, but you guys have the Q&A too. So stem cell bonds, is there anything in the initiative that requires California to get a piece of the investments? It seems like the money benefits private pharma, et cetera.
Yes, the measure itself does require the state to get some part of the patents. So there is a formula, and there are provisions. I would have to look at the very specific ones, but yes, California will be the recipient of some of the money that comes out of any inventions that they were part of.
Okay, Prop 14, this is either a question or an answer. Only a majority vote needed on Prop 14, is that correct?
Yes. Okay. 15, what's the rationale behind the reassessment every 3 years? Where did the 3 years come from?
I think that was to give the county assessors who just do not, like the county assessors who are opposed to Prop 15, and which is atypical for them, but their complaint about Prop 15 is essentially that they don't have the staff, resources, or really the know-how to do a lot of this reassessment that's going to take place. And so one of the things that the proponents put in there, I think that 3 years in part, is to give the various county assessors offices more of an opportunity to get in there and take on this new expanded scope that otherwise, they would have to hire up something like 2X for, depending on the county.
Okay, 15, property is worth more than 3 million. Is that market value or current assessed value?
I don't know.
I am not sure. I think that it's current assessed value.
Okay. That's more of a comment. Okay, if 15 passes, would the commercial industrial property tax increase happen all at once, or would there be gradual increases over the following 3 years to avoid a potential 42-year jump in assessed values?
It happens. It can happen at any point during that 3 years, but when it happens, it happens. And so once an assessor comes in and reassesses a property at a value, that property owner is going to be on the hook. And what the Mary Beth pushed back me on this, but what the no side would say is that if you're a commercial tenant under a triple net lease, that means also that your rent then is going to go up.
Okay, next one's interesting. This is sort of the more subtle no point. How would residential landlords be affected? I thought only commercial properties and industrial are affected by Prop 15. So I think Ned, you may want to clarify the.
Yeah, I think I'm 95% sure on this, that like if you own a 12-plex, that you're essentially a commercial property owner, because it's not the use of the property, it's what the property owner uses it for, which is a commercial purpose. The fact that purpose happens to be providing residence to people doesn't mean that it's not a commercial purpose. What they're talking about is residential owners, right? Which is people who own a residence own a property for the purpose of living there.
Okay. Does Prop 20 increase the length of prison terms and reduce incentives for inmates to engage in efforts to earn release on parole?
I'm not sure.
Prop 20, sorry, I'm trying to catch up with you and reading the questions. The length of prison terms, it definitely reduces incentives for inmates to engage in efforts to earn release on parole. In terms of adding to prison sentences, I think only for the new crimes of the organized retail theft and the serial retail theft. Mostly it does expand the crimes that you can collect DNA for, and it also focuses on the parole and de-incentivizing people doing things to be released on parole.
Okay, and some of these, let me apologize in advance because we're gonna run out of time. They appear in reading them quickly to be more comments and questions. This one says very poorly thought through statute, and that's okay. That's a fair comment, but I'm gonna kind of scroll through some of these. Oh, is this being recorded so I can watch it again later? Yes. 21, speculation that Prop 21 goes down, rent control, etc. Okay. Oh, okay, here's, will Prop 22 insulate Uber and Lyft from liability for misconduct of its drivers?
That's a question for an employment lawyer, or maybe Mary Beth knows the answer to that.
I think in some situations, yes, because our employment laws are often built around ideas of respondeat superior liability for employees, but not necessarily for independent contractors. So I imagine that there would be some situations in which it would.
Okay. Oh, here's Saul. Good to see you again. Thank you. Here, 7/8 vote attached to yes on 22 seems predatory, manipulative to voters. Is this approach standard practice or does it speak to something else?
Yeah, so Mary Beth, I'm sure, is going to have some thoughts on this one. So I'll just explain the rationale behind it. And the rationale behind it is in part driven by the fact that this measure, the rationale for it was driven by legislative action, and was driven by legislative action that I think was very close to a 2/3 vote. And when you look at that, plus you look at the general trend in California politics of Republican seats disappearing, probably going to happen again this year, and the Democrats really becoming a whatever is on the other side of supermajority. Is that an Uber majority? Super duper majority?
Super duper majority.
Super duper majority. I mean, so it's essentially, it's a protective clause, right? And we've seen some supermajority language in a few other measures. I suspect, to Mary Beth's point, you're going to see those increasingly. You're going to see those increasingly in measures, particularly being pushed by interests that think that the legislature is on the opposite side.
So I'm going to say it is not standard practice to see 7/8 vote requirements, but I will say that, again, I think it's important to understand that the default is there's no amendment at all by the legislature. So this does maybe put a toe in the door to say, if we created something that has an unintended consequence that everybody knows was a drafting error, or was really something that is so obvious to everyone that needs fixing, we'll let the legislature fix it. But we don't want the legislature tampering with anything that is even slightly controversial without going back through a vote of the people, which is the default. So I think, to be fair, while it is kind of outrageous and as a practical matter, I don't think it's super helpful, I do think that there is that one tiny kind of thing where you say, well, if everybody agrees that this needs fixing, the legislature can do it, and we will avoid the expense and hassle of going back through the ballot.
Here's a thank you to Mary Beth for being neutral in her analysis, which differs from this participant's experience with some law professors. Okay.
This one I think is okay. Does 24 take away a private right of action? The voter's guide suggests it reduces private centers, two different questions, but I want to do the first one, which I think is cleaner. Does 24 take away a private right of action that exists now?
My understanding is no, there is not a private right of action now. It just does not add one. Ned, you may have a different understanding.
I think that's my understanding too. Although again, honestly, 52 pages, it's over my head.
It's a lot to get through.
Okay, 23. I'm sorry. Yeah, is risk assessment by pretrial service agency only a recommendation and not a determination of the release decision by a judge? I think you touched on that, but I think that's a little unclear.
I think it is a little unclear. I think that it is supposed to be a recommendation. I think the concern is that there needs to be the creation of a pretrial services department, or it can be contracted out to like a regional or a countywide pretrial services assessment group. And there's always some discretion that the judge can either take or not, but I do think the concern is that the assessment tools that they are using and the algorithm-based risk assessments are likely to disproportionately impact people of color and people who are economically disadvantaged. And so I think that that's the underlying concern, even if a judge has some discretion to depart upwards or downwards from whatever the computer system produces, but that having that as the basis for the assessment is problematic.
Okay, we got about 2 minutes here. I think we can do it real quick. Does Prop 13 already allow those over 55 to transfer current property tax value? How's 19 different? I actually know I can do that one if it's okay with you. Yes, under current law, it's only if the second house, the second property is lower value and only within the same county, unless the other county opted in, which is true for some or all counties. So Prop 19, it would not matter whether the second house is more, and it would not matter if it's in the same county or not. And you guys tell me if I got that right.
Perfect.
Thank you, thank you. Another thank you. We got like 2 minutes left. Okay, that's a sort of rerun. And I apologize if I missed any of these, but we're going to save the chat and hopefully. Okay, last one here, 1:29 p.m. On would Prop 21, would this cause LA rent restriction on rent increase to be eliminated? Who does this most benefit, landlords or tenants? Prop 21.
I don't know the answer to that, Mary Beth. I thought this was permissive for local governments, not restrictive.
It is permissive for local governments and not restrictive. I don't know I'm not familiar with the LA's current rent requirements. I do think that this would give more leeway to local governments, and in answer to who does it benefit, it definitely does not benefit landlords. So there's an argument to be made that it benefits tenants, and but I don't think that rent control in general benefits landlords.
Okay, 1:30. I might be able to squeeze one more in. There was a question about court challenges. I think before the fact is different than after the fact, but there was a question about whether you're anticipating any court challenges to any of these after the fact.
Yes, well, definitely. There's already an ongoing court challenge that's a little bit on hold on Prop 20. And that one will resurface if 20 passes, because Proposition 20 was qualified as an initiative statute, but one of the things that it does is impact the parole considerations that were part of Prop 57, which was a constitutional amendment. So there's a pretty good argument that in order to amend a constitutional amendment, you need to do a constitutional amendment and not a statutory initiative. And because Prop 20 only got the signature requirement for the statutory amendment, then it's very likely that that will that litigation will complete and possibly the parole parts will be stricken from the initiative.
Okay,
Like,
thank you. Go ahead.
it's pretty rare. You know, most of these ballot measures are drafted by ballot measure attorneys and probably by a handful of firms, probably by the same 6 to 8 firms on, 3 to 4 firms on either side. So, you know, if there is an issue like the one Mary Beth just raised, it was probably a conscious decision in this instance by the proponents, a conscious take on of risk to avoid having to spend the additional money to go out and qualify a constitutional amendment, which for this measure, for this year, you needed 1.6 million actual signatures, which boils down to around 1 million signatures. And so it's a big jump over the actual 1 million statutory required 623,000 signatures that could cost a campaign something like $3 or $4 million or $2 or $3 million. So sometimes you'll see something like that, but if they're drafted by an interest group with enough money to pay for it, they're usually paying for pretty good lawyers as well.
Okay, we are at 1:32. I mean, I'm happy to stay on for one more. I think this is an easy one. Prop 22, will a no vote allow part-time only drivers who would otherwise qualify as independent contractors to continue to be considered independent contractors, thereby really only requiring full-time drivers to be treated as employees? Ned, the answer is
No, there's no distinction between part-time and full-time drivers under the measure.
Okay. And that's really it. I respect everybody's time. I really thank the speakers. I found this to be very informative, and that's it. Stay safe.
I just want
Go ahead.
to say thank you to everybody for your civic participation and in being a member of CLA, which is important, and also like paying time, like take some time out of your afternoon to bone up on this stuff, and just would encourage everybody to go vote.
Yep. Early. Vote
Thank you,
early
Saul.
and
Thank you.
safely.
All right. Thank you all. Take care. Stay safe. Bye.